Yeah, so good day everyone. I'm taking chapter 7 today, which is contract of employment. So what comes to your mind when you hear the term employment? Now, everybody knows that if they say okay, someone has been employed, it's just simply saying you've gotten a job. So contract of employment is simply talking about that your job that you've gotten, the agreements you have between you and your boss, you and your guy, the agreements. That is what contract of employment is governs. There are some rules that are regarding it that must not be broken. There are some duties that the employer has, the boss has, and there are some duties that the employee has or the worker has. And there are some laws that also must be followed and some rights that the employee cannot be denied. Now, this is what we are going to be talking about in this chapter. It's a very interesting chapter. Okay, so employment law. Of course, employment law, anything employment is under labor law. Now that is quite obvious. Now labor law, of course, employment law is an aspect of labor law that revolves around the contract of employment between persons for the purpose of learning a trade and looking for wages. Now a contract of employment is a voluntary agreement between an employer and an employee, under which the employee, for a money consideration or remuneration, promises to render services to the employer. Now at that point is simply analyzing the definition of a contract of employment. Now, he's saying number one, it's a voluntary agreement between an employer and an employee. One, voluntary agreement between the employer and an employee. Of course, you cannot, a boss or the employer cannot force the employee or threaten the employee under duress to come and work for him. It doesn't work that way. Or the employee can't force or cajole the employer to come and work for him. It doesn't work that way. It won't make any sense. So number one, it must be a voluntary mutual agreement between the two of them. And also it's for a money consideration or remuneration. Now this is simply saying the employee is not Father Christmas. He's not going to be coming to do his work for free. Of course, you have to pay. So now that is why I said it's money consideration or remuneration. And that money consideration or remuneration sometimes is called wage, sometimes it's called salary, depending on the type of employment. And also to render services to the employer. Now, the consideration on the part of the worker is, of course, is rendering his services to the employer. The consideration on the part of the employer is paying some form of remuneration to the employee. Now, of course, it's also important in this part to distinguish between a contract of service and a contract for service. Now, they are actually quite similar, but they are very, very distinct. A contract of service. Now, if you can remember when we were doing torts, law of torts, under vicarious liability, we said a master is liable for the civil wrong and the actions of his servants, and it also works in an employer-employee relationship. Now, that is an example of a contract of service. Now, it will work in a contract for service because if you can remember, one of the exceptions to the vicarious liability principle is that of the master and the independent contractor. The master is not liable for the wrong or the actions of the independent contractor. Now, that is an example of a contract for service. Now, it's the way they are different is basically number one, the nature of the work, and number two, the liability attached. Like I said, the master is not vicariously liable for the action of the independent contractor. However, he is liable for the actions of the servant. Also, in determining whether an employee is a servant or independent contractor, some tests are employed by the court. Now, I know it's quite similar. It's quite possible in some scenarios where, okay, the master or you employed someone and the person should commit a civil wrong in which the master should actually be liable. But then, based on the fact that he knows a little about the law, you can write under the fact that, okay, this person I've employed is an independent contractor. They are saying the court will still have to check and verify whether such a person falls under the name of employee or independent contractor. And they are saying there are different tests in which they employ, one of which is the control test. Okay, so now they are saying, of course, the control test is, it is said that a servant is a person subject to the command of his master in the manner in which he does his work. Of course, one major difference between a master and a servant and an independent contractor is the manner in which they do the work and the influence the master has in controlling the way they do the work. Let me give you an example. If you are being employed as an accountant, of course, part of the main reasons of you taking this account professional exam is either you want to the sole aim is to be a chartered accountant. However, some people want to be auditors, some people want to be investment bankers and the likes. So let's assume you want to be a chartered accountant and you've been employed by a company now. Of course, the way you carry out your work is going to be determined by your boss. Your boss can you can write a statement in a particular way, you write a report in a particular way, and it tells you, okay, no, I don't want you to write it this way, write it in another way. Or it's going to tell you this is how you do this, this is how you do this, this is how you do this. However, for an independent contractor, the master has no control over the way he does his work. An example is if you invite a firm to come and audit your company, you are not the one that is going to sit down and tell them this is how you audit it, this is how you audit it. They won't listen to you. But you invite a carpenter to come and mend or adjust some broken furniture in your house. You are not the one that will tell him this is how you do it, this is how you do it. He has the necessary skill and knowledge to be able to know how to handle such a task. Then, however, some cases have rendered the control test inapplicable. Of course, the control test is actually like the principle behind the control test is really vague in the sense that if you actually going by the control test, it means you are saying every independent contractor, or rather every professional, will automatically be an independent contractor. However, there are some situations where a professional would actually be an employee of a company. An example is a medical doctor. If a medical doctor makes a mistake, let's say he forgets one of his equipment in the body of a patient after surgery. In that kind of instance, the hospital which employed him, who is working for, is going to be liable for such actions. Now, he's not an independent contractor in that instance. However, if you go by the control test, you'll be deemed as an independent contractor. And of course, there are some other questions that they will ask in determining whether or not the person is an employee and independent contractor, of which some of them include one, whether or not the person forming the contract, whether or not the person performing the service is to provide his equipment, whether or not he is to hire his own helpers, the degree of financial risk he takes, the degree of responsibility for investment and management, the length of the period, whether temporary or permanent in nature. And that length of period is simply saying if you employ someone, depending on whether it's a temporary employment or a permanent employment, it would go a long way in determining whether it's an employee or an independent contractor. Now, if you employ someone to be your sales boy or sales girl in your business or your restaurant, now that of course there is no security of employment in that instance. However, you plan on employing the person for an unforeseeable period of time. So you can call that permanent in nature. However, if you hire a contractor to come and build your house or do something for you, that employment is temporary. Then formation of the contract of employment. Now, this one deals with capacity to enter into a contract of service, and the same thing that applies in contract of employment is the same thing that applies in virtually every contract. That of course the normal rules, the general rules or the general law regarding law of contract, the basic law of contract still applies here. So of course the capacity to enter still applies here. Now, concerning infants or young persons, it is governed by section 9. And it says a person below the age of 16 years old cannot validly enter into a contract of employment. If you are below the age of 16 years old, according to the law, you cannot enter into a contract of employment. However, you can enter into a contract of training or apprenticeship. Now, this is talking about most times, after you finish secondary school, your parents will say, go and learn work. Now, they are going to tell you to go and learn a trade or so. Some people learn catering, some people learn tailoring, shoemaking, mechanic works, and the likes. That's an example. And also, they said they must be paid on a daily wages. That's also another condition for employing someone below the age of 16. They must be paid on a daily wages. Then you cannot employ them at night. You cannot employ them at night or on public holidays. And also, you cannot employ them in underground operations, or you cannot employ them to work on machines or shipping vessels, or against the wishes of their parent or guardian. Now, those are the conditions for employing a person below the age of 16 years old. Number one, it must be a contract of apprenticeship. Two, it must be engaged on daily basis for wages. Three, not at night or for public holidays. Four, in underground operations. Five, on machines or shipping vessels. And six, it must not be employed against the wishes of his parents. Then also, there are also special protections accorded to women under the Labour Act. Of course, it's only women and children that have special protection. Women, or rather men, don't have any special protection under the Labour Act. So the Labour Act only protects the women and the children. And the first one is, of course, women are entitled to maternity leave of 6 weeks before and after their pregnancy. So it is within the right and is stipulated by the law that an employer must give a pregnant woman a maternity leave of 6 weeks and before her pregnancy or her due date, before her delivery date and after her due date. Now that is simply, of course, most times it's not actually applicable. Most companies just give them like 2 weeks or sometimes 1 month before and after, just 1 month, which is not supposed to be so. Then they shall not be given notice of dismissal during their absence, even if they remain longer due to illness. Of course, if an employee, a pregnant woman, should remain longer due to illness, of course, if it is a reasonable length of time, they should not be given a notice of dismissal. And also, normally, even if she doesn't stay long, you shouldn't give a pregnant woman a notice of dismissal during her absence on maternity leave. It's against the law. And as usual, they shall not be employed on night work, nor shall they be employed on underground, except the woman is holding a position of management. I mean, like she's a general manager or so. They shall not be employed at night, nor shall they work underground. The form of the contract of employment. Of course, this is talking about the form in which the contract will take. So now they say there's no particular form. No particular form is required. It may be oral, it may be in writing, or even by conduct. Section 49 of the Labour Act, however, stipulates that the contract of apprenticeship shall be in writing. So if you want to enter into contract of apprenticeship with someone, it should be in writing according to Section 49 of the Labour Act. However, most Nigerians don't actually follow this rule. I mean, most times, if someone wants to learn tailoring, you're going to just go there and negotiate with the man that, okay, you collect 20,000 and teach my daughter everything you know about tailoring for like 2 months or 3 months. And you might say, okay, that is just an example of a gentleman agreement. And most times they don't actually break it. So no harm, no foul. Then terms of a contract. The meaning of terms of a contract, terms of a contract are quite simple now. They are simply the conditions in the contract, the rules regarding the contract, the do's and the don'ts of the contract, how you carry out the contract. Everything is supposed to be inside the terms of the contract. What you are going to be entitled to inside the contract. The terms of the contract of civil servants are usually contained. The civil servants are usually contained in their conditions of service. Now, in the private sector, the term may be contained in a written document validly signed by both the employer and the employee. And of course, it will contain issues relating to their remuneration, other wages or salaries, their duration of employment, their benefits, probationary period, duties, pensions, termination, and the likes. So then we are moving on to term under employment, which is probationary period. Now, this is usually a period of trial for a new employee. The employer takes the opportunity to study him well, as well as test his skill and suitability for the work of the employer. Now, a probationary period is simply a period where the employer, you can put in your own terms, is where the employer undertakes to study and observe the employee's suitability to his organization, or to check whether he has the necessary skills and suitability to adapt to the organization. Now, it's simply saying, okay, there are some times that it can either be the employer has employed the employee, the employer has employed you and is not sure you are competent enough to carry out the work. You can just place you on probation. Now, that means it's going to be monitoring you for that particular period of time. It might be a month, it might be 2 months, it might be 4 months. It is at the discretion of the management, actually. Or and also it might not necessarily have to do with your skill. It might have to do with the weather condition. For example, now you want to relocate from Nigeria to, let's say, Alaska or Canada. Now you know those places are very, very cold. Now if your boss can place you on a probationary period to see if you can cope with the weather before he decides whether okay he's going to transfer you to another branch. So that's a probationary period. It's just to test your skill and suitability for the work. Now duration. Now first, the duration of the master servant relationship must be stated. Either it's going to be for a definite period of time or an indefinite period of time. Now the relationship may also be for a particular project, in which case it will be terminated upon the conclusion of the project. An example is you employ a contractor to build your house. Once the house is built finished, you and the contractor have no business except you not build him. Then the distinction between a contract for an indefinite period and one stipulated for a definite period is mainly regarding the mode of terminating both contracts. While a contract of employment for an indefinite period could be terminated by reasonable notice or payment in lieu of notice, a contract for term cannot be terminated until the expiration of the term. The duties of an employee. Now, this is really saying an employee owes some particular duties to his employer, which he must carry out. Now, the first one is duty to obey the employer's lawful orders that are within the term of the contract of employment. So your employer should employ you, and within the time of the contract, he lists some of the duties and some of the things you are going to do. Now, those are the things that you have a duty to carry out. So when they are lawful and they are not contrary to public policy. A popular example is for secretaries. Okay, I've never had a secretary, and I've never known someone who was a secretary. But from the movies I've seen, if the boss can tell the secretary to go and photocopy something for him, to go and print something for him, anyway, they can even give the secretary money to go and buy food for him, to go and bring coffee for him. Because those are things within the scope of employment of the secretary, and she definitely has, or he definitely has to carry out those orders. Then duty to exercise the professed skill and diligence. Now that part is simply saying before your boss employed you, you must have told him you could do some particular things. Most probably you told him, of course, you are a chartered accountant, you're not telling you are good with Excel, you are a graphics designer and the like. So if, let's say, in the course of the employment there is need to make a graphic design, and your boss should do that, instead of outsourcing this work, let's just give this guy, he says he can do it, let's give it to him. Of course they are saying you must do the work perfectly well because you've already professed such skill. The duty to do that for which he is employed or other closely related things. Of course, this is almost the same thing as the first one. They are saying you've been employed to undertake certain tasks, and they are saying there's a duty on you to carry out what you've been employed to do. Then the duty to render personal service and not delegate his duty without the consent of the employer. Of course, that point is very important. He's saying you shouldn't delegate your duty. You shouldn't delegate your duty to any other person. You shouldn't assign your work to any other person without the consent of the employer. Then duty to keep his employer's confidential information and trade secrets. Of course, that part is simply saying don't be a big mouth. Anything your employer tells you in confidence, or employer's confidential information, most probably books of record, the amount of revenue they make, their trade secrets, their formulas and the like. You shouldn't blab it out to unauthorized person. That's simply what that point is saying. Then duty to serve the employer faithfully and not put himself in a position where his interest will conflict with that of the employer. Of course, they are saying you should always avoid situations where there will be conflict of interest between you and the employer. Then I'm moving on to the remedies available to the employer or master. Remedies available to the employer. Number 1, to dismiss the employee when the employee has committed an offense. Of course, this is actually the number 1. I mean, if your boss should hire you to do something and you commit an offense, he's the one that employed you. He has the right to terminate your employment. That's what that point is saying. Then the next one is duty to suspend the servant for breach of duty or default. Now there are sometimes, of course, they are going to place someone on suspension. It might be that your employer ordered you to do something and you failed to do it, or you defaulted in some duties and responsibilities, you might be placed on suspension. Then to sue the servant for indemnity and loss in respect of in respect of losses incurred as a result of the servant negligence. Of course, now you know in some instances, okay, let me use bakery now as an example. Bakery as an example. If they make cakes now, and they almost done with the cake, but due to the servant's negligence, most probably he didn't set the oven well and he burnt the cake. Now, you know, of course, you know the employer is going to incur an extra cost in making another cake again. So now they are saying he has a duty to sue, or he has a right, or rather, to sue the servant for indemnity for loss in respect of that loss. You want to sue the servant in order to enforce reasonable constraint of trade. Now, reasonable restraint of trade is simply saying, okay, of course, let's say the employee was an integral part of your organization and now is leaving. Of course, you can bring an action to enforce a reasonable restraint of trade on it. Then to fire, disengage, or dismiss the servant without formalities. Of course, the employer has a right to fire the employee or dismiss him and it's at his own discretion without any formalities. So the duties of the employer, to provide work for the servant. Of course, you can't employ someone and the person will come to you to his place of work in the morning and you just tell him, okay, I don't have work, or you just sit down there and be looking. It's your duty to provide work for the employee or the servant. Then duty to pay his wages or remuneration in the legal tender, such as a check. Of course, it can be paid regularly, that is, so now we are saying it can be paid weekly, fortnightly, monthly, but no longer than monthly. So now if you are going to pay the employee, you must pay him regularly, you can pay him weekly, you can pay him daily, you can pay him fortnightly, monthly, but no longer than monthly. Then to provide written statement of the terms of employment within 3 months after he has assumed his duty. So now they are saying if you enter into a contract of employment with someone, the employer has a duty to make sure he provides the employee with the terms of the employment not more than 3 months after he has assumed his duty. Then duty to provide safe system of work, which entails provision of proper appliances and special provision should be made for handicapped and vulnerable employees. Of course, that means is saying this is part of the duty of the employer to make sure that there are safe working conditions for the employee. Then provision of competent staff. Where an employee is injured because of the incompetence of the colleague at work, the employer may be liable to the injured employee because it is the duty of the employer to employ staff which are sufficiently experienced to work. Now that part is simply saying employ people that are rightly qualified for the work. You can't go and bring someone with mere O-level to come and work as a chartered accountant in the bank. It is not going to work. The person is going to perform very poorly. So now they are saying you have to provide competent staff. It's your duty. Then provision of a proper system of work and effective supervision. Of course, this is simply saying control system. There must be an adequate control system in which the employees can't just behave anyhow in the workplace. There must be someone that must be regulating their actions, watching over their actions, supervising how they carry out their work, especially complaints from customers and the likes. The payment of expenses reasonably incurred by the servant in the course of his duties. Of course, it's simply saying you have to indemnify the servant if he incurs any reasonable cost or any expense in the course of carrying out his duties, maybe traveling expense, his hotel bills, and entertainment bills. The implement of compensation under Workmen's Compensation Act to injured workers. There are some other duties here, payment of paying redundancy allowance where they've been discharged for reasons of redundancy, then indemnifying the servant for losses lawfully and reasonably incurred, with explain that one. Then leave vicariously liable for the servant's theft. Of course, this is actually a very funny duty. They are saying it's the duty of the employer to be vicariously liable for the actions or the wrongdoings of the servant. That's what that was as an example. We all know various examples. If someone that owns a restaurant now, as he does home delivery services, and he has a delivery guy and he sends the delivery guy to go and deliver the food to the customer. Now, even on the way, the delivery man should have an accident and he spoils someone's car. So now they are saying it is the duty of the employer or the owner of the restaurant a reliable and fixed lacquer. Then the next subtopic is termination of a contract of employment or a contract of service. So now, of course, a contract of service can be terminated by natural events such as death. If the employer or the employee should die, is frustrated. Frustration. Frustration is simply an act that is beyond the control of both parties and is not the fault of either of them, but which leads to total incapability to perform their actions under such contract. Then operation of law. Operation of law. Now, operation of law can include compulsory rounding up of the employer's company. Of course, if it's a company and the company is wound up, the contract of service between the employer and all his employees is terminated. The solution of partnership, compulsory conscription of the employee during time of hostility of war. This one is really talking about if there is a war now and they compulsorily recruit the employee to come and fight. An example is what is happening in Ukraine and Russia. Of course, they are saying that contract of employment between the employer and the employee is terminated. Then prolonged illness of the servant, mutual agreement as when the adult work is completed. Now that is saying if they employ you to perform a certain task and you perform the task, then the employment is terminated. Then termination by the employer, then by notice, and where a contract of employment is not for a term, an employer can determine the contract in accordance with the terms. In these terms will usually include one, giving of notice of a fixed time or reasonable time. Of course, they are saying if you want to terminate someone's contract, you have to give him a reasonable time, a fixed time, or you tell him that okay. In some companies now, if you want to terminate your contract of employment, let's say you work as a lecturer, I think it applies for lecturers. You must have given them the termination notice 2 months before you actually intend to leave your place of work. And I guess it's mainly so that they can find a suitable replacement. And also the employer must pay salary in lieu of the notice to cover the number of days that the notice will cover. Then however, the employment is for a fixed term, the employer cannot determine the contract before the fixed duration and will be liable to pay the employee in damages for wrongful termination. Of course, this one is saying where the employment is for a fixed period of time. Let's say it's for two years now. You can't terminate the contract of employment of the employee and those court we are going to be required to pay some form of compensation. An example is footballers. Of course, if you want to terminate the contract of a player, the club is going to have to pay him up. Or all these managers, they can't just terminate their contract, the club will have to pay them off. In the case of civil servants, obviously our court has distinguished between a person in civil servant, whether of the state or federation, and a person employed by a private establishment. Now, civil servants may have a right to work for the employer for life until the normal period of retirement. The effect is that the employment cannot be terminated anyhow, and where it is wrongfully determined, the court would under reinstatement. Like I said earlier, even between a civil servant and someone working for a private establishment, the security of appointment in under the civil service, all other things being equal, if you are employed as a civil servant, you are going to work there till you retire. That's why I say all of that things being equal. You are supposed to work there till you retire. And if your contract of employment is unlawfully terminated, the court would order reinstatement. Now, dismissal of an employee. Dismissal is the removal of an employee without any formalities by the employer. Dismissal may be effected in the following instances. A. Act of conduct likely to bring the employer into disrepute. If you are carrying out some actions in which you are embarrassing your employer or you are disgracing your employer, you are bringing into disrepute in public, he has the power to actually dismiss the employee. Where the servant's practices or conduct expose the master to loss of public confidence, then gross immorality, absenteeism without permission if you don't come for work, gross misconduct include insubordination, habitual drunkenness, gross negligence, and disobedience of lawful order. Then it has been severally held by the court that an employee cannot be dismissed without being heard, as this would be a breach of his fundamental right to fair hearing. Under section 33 of the Constitution. Then where an employee is alleged to have committed a crime, an act that amounts to an offence, he must be charged to court for that crime. Then interdiction. Interdiction is also another term of employment. It's simply the suspension of an employee pending the duration of the criminal charge against him. If at the end of the criminal trial the employee is charged to court and acquitted, he will be reinstated. A very good example is what is happening between Greenwood and Manchester United now. Of course, he has been charged with attempted rape and assault for like 1 year now. Before the charges were dropped, Manchester United had ordered him not to train with the squad or come to their training grounds or center. That's an example of an interdiction. When an employee is temporarily suspended due to the determination of a criminal charge against him. So that we are done with contract of employment and I'm moving on to the practice question.